It is not. No, it's totally inapplicable to other sports because they say they didn't rely on it, and it makes no sense at all. I mean, if you were running the National Football League, you would have thought you were exempt, but some player sued the National Football League at some point in this process, and the court said, no, that rule is for baseball. It makes very little sense. There is an open question, which is as to whether it applies to everything about baseball or only sort of the core things that you need to make a baseball league run, contracts and players and things like that. So, for example, somebody sued one of the baseball card companies and Major League Baseball for conspiring to monopolize the baseball card business, and a lower court said that was not exempt. Didn't get to the Supreme Court, so you can't really tell how it's going to come out. And the minor league baseball players have recently sued Major League Baseball for being paid so poorly. They're paid by the major leaguers, not the minor league teams, which I'm happy for since I own a small part of the Lake Elsinore Storm, one of the Padres minor league teams, and I'm quite happy somebody else pays the players, and I'm really happy somebody else is the defendant in the case, because the theory of the case is the minor league players are getting underpaid, and the underpay is a violation of minimum wage, overtime rules, and the antitrust laws, because the major league teams all agree on exactly how much you pay minor league players, which is very, very little. So we'll see if the courts think that that's a core part of baseball, or it's only the minor leagues and it should be subject to ordinary competition. We have some intellectual property issues in the sports world. Probably you guys deal with intellectual property issues all the time. We had a big case involving fantasy leagues. Everybody know what a fantasy league is? You pick your players, and so they compete sort of in theory in the virtual world. And the players decided that they were the stars of this show, and you should have to have a license from them to use their name. They said to use their name and image, but actually the fantasy league that they sued was smart enough not to use their images. And they were also smart enough not to use the names or logos of any of the teams. So when you went online to pick your players, it said Derek Jeter. It didn't have a picture of him, which would create an image issue. It didn't say New York Yankees, which might create a trademark issue. It didn't have a little Yankees logo, the NY or the circle, which might create a trademark issue. It just said Derek Jeter, and it had his statistics from last year, or whatever the heck they put, where they, I don't play fantasy league, I don't know how you do it, but you go online, pick Derek Jeter to be your shortstop on your team. So the union, on behalf of all the players, sued the fantasy league and said that they needed a license and ought to be paying them some share of their massive profits for running a fantasy league. And the Eighth Circuit ruled that this was protected by the First Amendment, that you could, just as the New York Times could run a story saying that Derek Jeter got 3 hits yesterday and not have to pay Jeter a license for using his name to sell newspapers, fantasy leagues could run a league saying, come take Derek Jeter, or Jose Rodriguez, or Tony Gwynn, or whoever, and play against your friends and compare your statistics, and do it on our website and pay us a fee, and you don't have to pay either. This was considered an outrageously terrible decision by most of the sports lawyers who are not intellectual property lawyers. I don't know. We have people around the room who are steeped in intellectual property. They know more about it than me, but I thought it was not that bad a decision, because I thought it was fairly parallel to the New York Times. But anyway, so we've now advanced from fantasy league cases to video game cases. I can manipulate my Charger team, or players, or whatever, and Valerie can manipulate the Raiders team. We can see who wins. And they pay the current players, but the problem was they also had, part of it was called like the Legends part of Madden football, where you could play the 1967 Green Bay Packers against the 1980 Pittsburgh Steelers, 2 Super Bowl teams, and see which one would win. And again, I could be playing one, Valerie could be playing the other, and they didn't pay the retired players anything, because they were essentially making payments to the union, and the union was giving it to the current players. And it created a huge fuss because they were using the images of the retired players and their names. and their statistics, although the statistics would appear to not be that valuable if you think the fantasy league case is decided correctly. And the players sued EA Sports, which owns Madden Football, but even better, the players sued the union, because the union sort of kind of represented to the retired players that they would take care of them, and sort of kind of represented to EA Sports that they had the authority to license for them. So they basically got killed. The union got killed by the players, and that mooted out the problem of whether they had a valid suit against EA Sports. So we shifted to college sports, where a gentleman named Ed O'Bannon used to play for UCLA in basketball, quite talented player. They won the national championship one year. He was as the story goes, you have to have a good story to have a lawsuit. He was in the backyard barbecue, and his nephew said, Uncle Eddie, come over here. You're on my video game. And he walked in, and the kids were playing EA Sports NCAA basketball, where again you can play Duke against North Carolina 2014 against your friends, but you can also play championship teams against each other. And sure enough, there's the 1985 UCLA basketball team playing who knows who, some other excellent team. And the player playing center for UCLA, there's no name on his jersey. His number is the same number O'Bannon wore. He's African American, which O'Bannon is. He's 6'9", which O'Bannon is. He is listed on the statistics as weighing like 235, which is what O'Bannon did. And of course, these games are all programmed so the player is likely to perform as he performed as a human being. And he's programmed to average exactly as many points and exactly as many rebounds as O'Bannon did in his senior year at UCLA. So O'Bannon says, that's me. You're using me. And you're not paying me. And they had a license from the NCAA, blanket license, which allowed them to use any college athlete ever, and to pay a very large amount of money to the NCAA. So 2 suits were brought. O'Bannon and his buddies brought 2 suits. It was all coordinated. One suit was an intellectual property case against EA Sports. I think it's the same company. Whoever runs the college sports game, saying it was a violation of their right of personal publicity. But because there was a payment being made to the NCAA, and because the players had all signed scholarship contracts back when they were young, and the scholarship contracts gave the schools all their intellectual property rights relating to their years of play at the school, which were then all given to the NCAA for payments back to the schools. He had kind of contracted away the whole case, if you look at it that way. It's a contract of adhesion. But just in case you don't like contracts of adhesion, the other ball players brought the other half of the O'Bannon case, brought it as an antitrust suit. And their theory was that the colleges colluded to all offer all the players the same deal. So, again, as they explain the story, they say if O'Bannon had gone to, the UCLA coach, if he had been a great high school star, which he probably was, went to the UCLA coach and said, I want to come play for you, coach. Coach says, great. He says, well, I want a scholarship. Coach says, yep. And he says, and I want my intellectual property rights. Coach says, can't help you. He says, I'll go someplace else. Coach says, good luck. And he goes over to USC, and he has the same conversation with the coach. He says, I'll come here to play for you, coach. You will beat UCLA this year if you give me my intellectual property rights. And he says, I can't do it. It violates NCAA regulations. You'll be ineligible. You'll become a professional. So then he says, well, how about if I get my intellectual property rights when I graduate? Can't do it. It violates the rules. So they brought an antitrust suit on the theory this was a nationwide conspiracy among the colleges to get the players. And of course, when you think about it, it's not just intellectual property rights, it's the whole shooting match. Because he could have gone to the UCLA coach and said, your scholarship doesn't actually pay for my books. Will you pay for my books in addition to the scholarship? And it doesn't pay for my travel to come from Detroit, where I grew up, to Westwood. I want to go back and forth 3 times a year. And also, I'd sort of like my mom and dad to come to the Final Four. If we make it to the Final Four, that sounds reasonable, doesn't it? And the coach will give him exactly the same answer. No can do, violates NCAA amateurism rules. So the antitrust suit, I don't remember what happened. The intellectual property suit got tied up on appeal. The judge denied a motion to dismiss and sent it up on appeal to the Ninth Circuit, where it's been sitting for 5 years. And the antitrust case went to trial, bench trial, and the plaintiffs won. So we now have a ruling by the trial court, Northern District of California, that it is a violation of the antitrust laws for the NCAA to do two things. The first is to limit scholarships to student athletes to anything less than the full cost of attendance, which is a defined term in the U.S. Code. And they don't give them the full cost of attendance because things like travel and incidental expenses are impermissible benefits. And then the second part of her opinion was it's a violation of the antitrust laws to decline to offer them a reasonable amount for their intellectual property rights. And she considers a reasonable amount to be $5,000 per year of competition placed in trust, payable after you graduate. And people said, well, where did she get that? The answer is she made it up. And then people said, well, who put her in charge of college sports? And I think the answer is nobody likes the people who are in charge of college sports, so many people are prepared to jump in and try their own shot. That's pending in the Ninth Circuit. It's on an expedited appeal because it will turn the NCAA system sort of upside down in a year. She stayed her order for a year and no more. So they're trying to get the appeal done in a year. I think that there are several things going on at the same time. The NCAA is trying desperately to make itself a less inviting target. So they have literally last week solved the problem of full cost of attendance. Scholarships are now permitted to cover the full cost of attendance. And they have also solved the problem of four-year scholarships, which we didn't talk about. They, believe it or not, had a rule that prohibited schools from offering players four-year scholarships. They had to offer them one-year scholarships, which were renewable at the option of the school, which means if the coach doesn't like you or you didn't have that good a year, you lose your scholarship after a year. But more important, it ties their hands. It means, again, that if you were the best high school basketball player in San Diego County and you were looking for a school, nobody could even offer you the incentive of a four-year scholarship to get you. So they've done away with that problem. Now four-year scholarships are permissible. They've done a few other things. So what's happening is they're madly trying to get student-athlete benefits up to a level which won't aggravate the courts so much that they will lose that case or the next case or the next case. Jeff Kessler, who's a big-time sports lawyer back east, has a case which is basically a pure free agency antitrust case on behalf of college athletes. His theory is college athletes should get what the market will bear. And if you or your kid or whatever was the best high school basketball player in San Diego, the next year there should be an auction for his services. And Duke wants him, they offer $25,000. Notre Dame wants him more, they offer $40,000. USC wants him more than that, they offer $60,000. Do I think that will happen? No. Do other people in the sports business who are quite smart, quite knowledgeable, and quite experienced think that will happen? Yes. So I don't know, but the notion that college sports is going to put up with, and fans are going to put up with, for example, one year T. Boone Pickens, who gives millions upon millions of dollars to the Oklahoma State athletic department, decides to give him $40 million and says, buy up all the best high school basketball players in the country and kick everybody's butt. And people are going to think that that's a good thing for college basketball. I don't think so. I think it's pretty unattractive. The Northwestern football players are trying to unionize. It's one of the many things going on. There's about three or four things going on at the same time. Antitrust cases trying to challenge the whole concept of amateurism and saying the players are the stars. They should be paid whatever the market will pay. If Oklahoma State will pay them $2 million a year to play at college, they should go to Oklahoma State and they should be allowed to. Then there's and O'Bannon is sort of a lesser form of that. Then there's the movement at the NCAA to sweeten the pot and to give the schools more individual flexibility so that you're not such a sitting duck for an antitrust case. You don't have all these restrictions on how much you can do, and each school can make its own decision as to how much they want to spend. San Diego State is not going to spend as much as Notre Dame on athletes. It's just not going to happen. It'll blow their budget out of the water. So you'll actually have competition, which is what antitrust law is about. It'll be fine for the players, Aztec fans are not going to like it. They're going to say we're going to gradually become irrelevant in Division I sports because you're going to have 20 or 30 or 40 super teams, and they're going to be able to offer every one of these kids more money and a better deal and a better dorm and more food and travel and fly their mom and dad to the Final Four, and we can't afford it. We're a poor little state university here. So sort of a third prong of the attack is organize the players into a union. And the reason that the organizers went to Northwestern rather than, for example, Ohio State is, if you think about it, state employees have lesser labor law rights, lesser collective bargaining rights than private employees, because every state has its own rules. And some of the best college athletes are in places like Alabama and Mississippi, and good luck organizing your union under the labor laws of Alabama and Mississippi. They're not exactly union states. But Northwestern's a private university. So if you're going to do this, you want to start with Northwestern, Vanderbilt, Duke, Stanford, someplace it's a private university. They went to Northwestern and they asked for a vote on having, they got enough players to put in cards, have a vote on whether it's going to be a union. But you don't get a vote until the National Labor Relations Board at its lowest level, the regional director in Chicago, decides that it's legitimate. And the question he had to decide is, are they employees or are they just students? And there were previous workers' comp cases by football players who got injured playing football, filed workers' comp claims. They all lost on the basis that they were not employees. They were students. So this is kind of groundbreaking that the regional director in Chicago ruled that the football players were employees. Their position was that the scholarship was payment and that they worked sufficient hours at practice and games, that they were employees. And the fact that they also went to school didn't mean they couldn't be employees, because think about a graduate student who teaches classes. He gets a paycheck for teaching classes, but he's getting his master's or his PhD, so he's sort of a dual purpose. So they then held the vote. They then locked up the ballots, sealed the ballots. Nobody knows who won. And Northwestern took an appeal to the National Labor Relations Board in Washington over the question of whether college athletes are employees. Discussing this with one of my colleagues at USD Law School, he said, I wonder if those students know they're going to have to pay income tax on their scholarships if this works out for the Northwestern football players, that's kind of an interesting angle on it that I hadn't thought about. But the problem with the union approach, again, it's another shot across the bow of the NCAA. It's a very unpopular organization, so it's sort of good for the overall gestalt of it, that more people are throwing bricks at them, and the bricks are of different sizes and shapes. But if you think about it, let's assume they win. So they have a union. So I'm the head of the union. I go and see you. You're the athletic director. I say, we want salaries, $25,000 a year. And you're going to say, can't help you. If I said yes, you'd all be ineligible under NCAA rules, right? And you can't play against Ohio State. They don't pay salaries because they're Ohio State employees, and nobody's been able to organize them under Ohio. Think about Wisconsin. Isn't Wisconsin where the governor took away a lot of the collective bargaining rights of the state employees? What's his name? Scott Walker? And there's a huge political fight over that. So how are you going to organize the University of Wisconsin football team under that kind of a rule? So you can't organize the rest of the Big Ten. It kind of turns the whole college scene upside down to think that you would have organized football teams and non-organized football teams competing together. So somehow I think it gets you to a dead end other than the publicity. The publicity is good. It's one more way that people can complain about how the NCAA runs its shop. And it's cleaning up a little bit.